Okay, welcome back, everybody. We're going to pick up where we left off, which was right here. We're discussing evidence in a trial in a remedial case. So we're getting toward the end of the remedial trial chapter. We discussed, as we ended last time, what evidence is and the difference between fact and expert witnesses and how they're treated differently. Expert witnesses have to be qualified. That is, you can challenge whether they're experts or not and whether you're going to receive their testimony that way. Fact witnesses are there for a specific purpose of proving the existence or non-existence of a fact. And therefore, sometimes they are barred from attending the trial until they testify, just so that you keep their testimony clean and clear and unadulterated with anything they hear from other witnesses along the way. And those are both all built into the rules for how we do this. And then, you've watched court shows on TV. If nothing else, you know how this goes. There's direct, cross, redirect, recross. Those are all allowed at essentially the moderator's discretion, but like everything else a moderator does, that can be challenged. If they allow questioning and redirect and recross and all that to go on too long, the PJC can say, we've had enough of that, we need to move on. One thing that's a little unique in our system is that PJC members can also ask questions of witnesses. I know from the one trial we did at the GAPJC level, that drives court reporters crazy because they have to know the name of every single judge up there so that they can get that correct. So if you're ever in that kind of situation and you're the moderator who's calling on those people, the way we dealt with that is the moderator called on them slowly by name when they wanted to ask questions. We didn't allow GAPJC members to just ask a question. They had to be recognized by name so that the court reporter could get it. So some of those things can be a little clunky in that setting. And that will be maybe even more challenging if you go the route of electronically recording testimony. Although if you're doing it by, say, a Zoom meeting, because you're doing it electronically, then you've got names and can put faces with it and all that. But just so you know, that's how that part plays out. And then after the witnesses are there are final statements. The complainant has the constitutional right to both open and close that section, with the respondent being in the middle. So they make an opening statement, then the respondent, then the complainant has a chance to end the debate and essentially answer what the respondent said. Then the PJC goes into deliberation on its own. Valerie.
Can you say something about time limits for opening and closing statements, please?
Sure. Those are all essentially up to the PJC to determine. So each court has its own. GAPJC has pretty firm traditions about that, but most of our councils don't have trials regularly, so you just said it. Okay, we're going to you get up to 30 minutes each, and for the complainant or appellant at the appeal level who gets to open it and close it, they need to say how much time they want to reserve. And then again, at GAPJC at least, there are time cards. The assistant clerk is in charge of letting them know where they are on their time. So they say, I want to reserve 10 minutes. So, okay, we're going to give you a stop at 20 minutes, and then the respondent gets their 30 minutes, and then you have 10 left. So it's usually a negotiated ahead of time thing so that everybody knows this is how much time you're going to have, which they want because they want to be able to prepare. So they want to know how much time they're going to get. So, that is one of the many things that happens at pretrial conferences often. That's where you talk about those kinds of things.
Thank you.
Okay. And then you go in private and deliberate. And to help prepare I have some more to say about that, but we'll get to it in a minute. First, I want you to go into breakout groups and consider document 3, which begins with some opening questions that are preliminary in nature. But then the second paragraph says, now assume that the complainant prevailed on the preliminary questions and the case is going to trial. What kind of evidence are you going to allow in? What type of evidence are you not going to allow? What are the issues you see? Who has to prove what and by what standard? What type of remedy will you suggest if the session has already sold the property and you fine for the complainant? What type of remedy will you suggest if you fine for the session? And some more questions. So what I want you to do is take document 3, get into your groups, and you know the drill now. Introduce yourselves, because this is a random assignment again. Read the whole scenario, all of you. You're going to have 15 minutes for this, so read through it privately, and then work on those questions together, and assume that you are now a PJC that is in the midst of getting this trial ready. And so you're going to be looking for evidence, and what is it you're personally going to be wanting to hear or find, and work through the pieces of that. That clear enough to get you there? Okay. Andy, go to it.
All right, away you go. 15 minutes. And when it says close, you'll have 30 seconds to wrap things up.
Welcome back, everybody. I don't want to, we could probably spend an hour debriefing this matter, but we're not going to do that because we don't have the time. But let me invite you to say in the chat any major learnings you got out of that, or significant questions that you ran into that you couldn't answer, or any solutions you came up with, anything that is particularly noteworthy. Feel free to put it in the chat. Yeah, so you're having some of the same discussion we had out here about, this is a property sale that could be a finalized deal that would be very hard to back up from. There's no provision in the book for a stay of enforcement if one is not requested in a case. There are ways that a presbytery can act quickly to stop something, assume jurisdiction, certain things that can be done and can be done fairly quickly, but this is a sticky one, and that's why we're not going to talk about it forever. I think the first comment said, say something about civil corporate law. What I'm going to say about that is, this is where you go to your presbytery attorney maybe and talk about your state law and how it plays into this and anything that could go in. Execute exemption for pass. Yeah, and the property exception is a tricky thing to deal with. You have to discover whether it was correctly done, if they were a former PCUS church, and whether they took the property exception. But the property exception does not have to do with whether you follow the Constitution for sale of church property, which has to be done by the congregation, not the session. That doesn't come into play in that part. And what presbytery has to approve may or may not, but that's a different matter. Okay, so we're going to move on from that. That was just to get you thinking about what a PJC does when it has facts before it, and when, even intentionally given you pieces in these breakouts to look at that were not easy or were not clear, because that's what the real world is like. If every case was cut and dried and clear, then PJCs wouldn't have much work to do. It would just simply be what it is. But things get muddy from different perspectives, and standing can be tricky. And so all those, reading the details of that when you get into a particular matter is important. Thank you for your time on that. So now let's go back and look at least some of the rules and process for when you're going into this. One important thing to understand, this is another one for the non-lawyers in the room, is the difference between fact and law. It's exceedingly important when you get, well, so the deal is in our court system in the church, not unlike secular courts, when something, the trial court is who makes the determinations of fact. So if you have a factual dispute that's before you, you as the trial court are making the decision on what the real facts are. Even if it gets to an appeal, we'll come to this later, but the standard of appeal, standard of review in appeals, that is what an appellate court does, says factual determinations by the permanent judicial commission that tried the case shall be accorded a presumption of correctness in appeals. Factual determinations are not to be disturbed unless they are plainly wrong, without supporting evidence, or manifestly unjust. Determinations related to the correct interpretation and application of provisions of the Constitution of the Presbyterian Church USA, our law, if you will, are not accorded the same presumption of correctness. So what gets reviewed later is how you applied the law to the facts that you determined. But if you are the trial court, you're the ones who hear the actual people give testimony. You're the ones who deliberate on that, and that does not get reviewed. So it's important that you try to get it right. So the most important thing for a PJC in a trial setting and deliberation, to me, is to determine what they think the real facts are. And the standard by which you decide that in a trial court in a remedial case is preponderance of the evidence. That's what it says. And that's D509. And you get a definition of it. That is one little bit of legalese, I guess, we left in, but still, it's the definition that's important. Where is preponderance? Preponderance means, this is D50901B, preponderance means such evidence as, when weighed with that opposed to it, has more convincing force and greater probability of truth. So that is the standard on which you make decisions in remedial cases. The book explicitly says that votes in remedial cases have to be counted and recorded on each irregularity or delinquency, and a majority vote is required to sustain it. There is a new provision. One of the things we heard was that a lot of decisions, the written version of the decision that then becomes part of the record of the case, and if there's an appeal, is the record, is the decision on appeal, were being composed in a very hurried manner. Because what happens is you deliberate for a day and a half, and particularly if you're at the synod level or the GAPJC level, which usually aren't trials, but still, people have schedules. You only have booked a certain number of hotel nights. You're at your deadline, and you got to get this thing done. So what we did was create a way to say, you can agree on what you're going to do, and you can have an outline, but you can then later compose it and come up with final wording. You can do all the wordsmithing to make it read well after you've adjourned. You have to have another meeting to do it, but even if you were in person for the trial, that meeting can be electronic, and it has to be within 10 days. So if you know what you're going to do, you've taken all the votes, you've got an outline of what the decision is going to look like, you can now adjourn, go home, and meet within 10 days to do the final wordsmithing. Communicate it a little by email, get it right, then have a meeting and approve it. There are some PJCs that were doing that anyway, but it wasn't technically legal until we now have it in the book. Does the second meeting require the same? Yes. This is if you're absent for anything, you're done. You can't participate any further. Was back at the loss of quorum and absences bit. So if you have to leave the deliberation, then you can no longer get back into it. Even if I remember those times well, we would have GAPJC would be meeting in private to do its deliberations, and somebody needed a restroom break and would get up and try to leave the room. The moderator would quickly call a recess, because if that person leaves the room and you're deliberating, then they can't come back in. So the same would be true for finishing this up. Bill, did that answer your question, or do you have something else? Okay. So yes, you have to have just the same people that were there, and when you get together, you have to have at least a quorum of them there so that you can finish that approval.
Really great. My question about if any of this is different for like a hearing on preliminary challenge, because it sort of follows the trial process, but it doesn't. It's hard to find where it says exactly do it this way in a hearing that might be different from trial.
Hearings. Well, I mean, they're still, what GAPJC was doing was hearings, and it's the same thing for deliberating on an appeal. Is not different. Trial and evidence are, it's a longer drawn out process of the same people, but I think it's still the case that you have to have a quorum there, and if somebody leaves and is not there for part of it, then they cannot come back in and be part of it again. Okay. Hearing on preliminary. Okay. Yeah. All right. So then there are also concluding matters of how you get done with this. Once a decision is there, it gets published, and there's a process for that. This is where the stated clerks come back in to get the paperwork done and sent out. The decision and order are binding, but only on the parties to the case, except for the GAPJC. Stated clerk be in the room for deliberations? No, stated clerks are not in the room for deliberations. They are not a member of the body that is voting. So they should be nearby so that they can be accessed for resourcing. And you can certainly take a recess and ask them a question of something about the Constitution, but outside of the deliberation, and then you get back and deliberate again without them there. Good question. Thank you. There is provision. There are provisions here, and once we move into the next part on appeals on new evidence. And I'll just tell you one of the changes in our process in church discipline is that in rules of discipline, when new evidence was brought in after an appeal had been filed, the appellate court could determine that it was going to receive that evidence and proceed with the appeal. We took that out and said, no, if there's new evidence, then the only option the appellate court has is to send it back and do another trial. So the first part of this is, what if new evidence comes in that could really have changed the outcome of the trial, and it comes in before there is an appeal? The answer is you do a new trial. The answer is also, if it comes in after an appeal is filed, that we'll get to in a minute, the appellate court determines it could have changed the outcome of the trial, then it sends it back, remands it for a new trial. So we do have provisions in for what if new evidence is discovered that really is significant and could change things, and the answer is then you try it again. And then finally, the stated clerk has the responsibility of building the record of the case, which is all of the paperwork ending with the decision. And that becomes then the chunk of paper that gets sent in an appellate process if one exists. And that completes remedial trials. So we now move to appeals. And I'm at this point going to call your attention to a piece of paper I forgot to call to your attention yesterday, which is another one of the handouts you have, which is preliminary processes. Well, let me stop and take that question first. Catherine, you have a question or comment?
Yes, you said the stated clerk gets the record together. Is it the stated clerk of the presbytery, or is it the clerk of the PJC? Because I'm reading D 5.1001 as being the Permanent Judicial Commission has its own clerk that is responsible for putting together the record, which I may have just heard wrong.
E5. The answer is whatever the rules say is what you do. So stated clerks certainly have responsibility, but the clerk of the commission has the responsibility of getting all the pieces of evidence right and all of that. Is that where you're reading? Clerk of Permanent Judicial Commission arranges in advance, identifies exhibits, records minutes and proceedings, prepares the record of the case, which consists of those things. So yes, that is true. And then the final section, stated clerk, if the council is meeting, the stated clerk reports it. If the council is not meeting, the stated clerk reports at the next adjourned meeting or meeting thereafter. So yes, that I apologize. It is the clerk of the Permanent Judicial Commission. I can tell you in practice, stated clerks are generally engaged in that process.
Yeah.
But yes.
And is that okay? At that point, is it okay for the stated clerk to get involved?
Sure. Okay. Yeah. This is what's gonna be the record that goes to an appellate process. So it's important that it be, indexed correctly. And the stated clerk was there during the trial. They weren't there for deliberations, but they were there for the trial. And so they're typically assisting with getting all the evidence passed and, numbered and all that kind of thing anyway. So yeah, I was speaking more from practice, but technically it's the clerk of the commission who has the responsibility in terms of who does the work. It's a team effort. Okay. So the piece of paper or pieces of paper, this is something that I put together for the GAPJC because, as we've already discussed, they're the ones who are most likely to have their heads in both sets of rules for a while yet, as things bubble up through the system and get to them that were started with rules of discipline. So I put together a 2-column piece, and this is not quoting the rules. This is Greg interpreting what the rules mean through these 2 columns. But we have one piece is remedial pre-trial process in both rules of discipline and church discipline. And the second page of it is remedial appeal pre-hearing process in rules of discipline and church discipline, just so you can see the things we talked about yesterday. Working through the pre-trial part is really the most complex thing that happens in PJCs. And so having it on a cheat sheet like this is helpful to have in front of you, especially during this time of transition. But you can see how things lay out in not constitutional language, but in explaining what happens where. So I just call those to your attention and note that the pre-hearing one actually goes on to a second page. So if you print it out, the way I have it is one page is the pre-trial part, and then another page front and back is the other one. So that's just for your use moving forward, really. Now, looking at appeals. One tricky one is that a lot of people in our church believe that once a presbytery finishes with something, it's done. So If there's an appeal that goes beyond them, it ought to be, I said that wrong, the session is so somebody in a church files something against their session. Those are the two parties to the case, right? The complainant and the respondent. The respondent can be the session, and so they have a trial at the presbytery level, and it gets decided, and the complainant appeals it to the synod. The parties are still the session and the complainant all the way through. So even though the presbytery made a decision, it's the presbytery's decision that's being appealed, and the parties are still the same. So the parties stay all the way through, and only those parties are the ones that can appeal it. Another member of the presbytery can't say, I want to appeal that decision because the presbytery's PJC got it wrong. It does not work that way. It's only those parties, and it's the same parties all the way through. Whereas remedial process begins with the filing of a complaint, a remedial appeal begins with the filing of a notice of appeal. And that has to be done within 45 days of receipt of the final order. That's the timeline. And we did make one change, and I'll take some ownership of that. It just never made sense to me that you filed that notice with the stated clerk of the level that issued the ruling. It's just both of them get it anyway, but it seemed to me that you should file it with the stated clerk of the level that's going to conduct the appeal, just the way you file the complaint with the stated clerk of the body that is going to hold the trial. So you file the appeal with the clerk of the council that will hear the appeal, with a copy to the stated clerk of the lower council. Rules of discipline, it was the other way around. And then there's a list of items that are to be included in it. That's in D60202. Name of the party, council from whom it's taken, a copy of the ruling, statement of the description of errors, and those are listed 1 through 7. And if there's a stay of enforcement, so the effect of the appeal is different if there's no stay of enforcement versus if there is. And at the appellate level, you have the ability to seek a stay of enforcement, even if one was not issued at the lower court. And so, whereas we tried to write this all out in one process, we did not want to repeat the whole how do you get a stay of enforcement part. So that's one place in the new rules where, I don't know if you noticed going through this in the how do you seek a stay of enforcement section, it actually has wording that says, or appellant in an appeal process. The complainant does this, parentheses, or appellant in an appeal. So you use the same, you have to go back to that section if you want an appeal, a stay of enforcement, and you're in an appeal section, but it can be sought. So the effect of the appeal is that it doesn't suspend any action of the council taken to implement the ruling being stayed unless a stay of enforcement was obtained with the original complaint, or one is obtained as described in the next paragraph, in which case the implementation of the ruling being appealed is stayed. So if there was a stay of enforcement in effect and a notice of appeal gets filed, then the stay of enforcement is still in effect, even if it did not prevail, that side lost, but that's being appealed, then you still stayed until the final action is taken. Very clear on that. As I said, I think yesterday, one of the things we tried to do to help minimize the amount of judicial process that goes on is make it easier to withdraw an appeal. And so now it is automatically withdrawn if jointly filed, unless challenged by a PJC member. So if there is a jointly filed withdrawal, the PJC members receive notice of that and have an opportunity to challenge it. And as long as they don't, within 7 days, this is D605, they have 7 days to file a challenge, in which case there would have to be a hearing to determine whether to allow the appeal. And the reason you would do that is at the end of that paragraph, if the withdrawal would defeat the ends of justice or be in conflict with the Constitution of the PCUSA, and therefore deny the request. So that's the standard on which it could be challenged. Preliminary process is not unlike the way it was at the trial level, but with different questions. It does include the standard jurisdiction question and whether the appellant has standing to file the appeal, which can be a little tricky. You know, this may have been a case that was thrown out because the complainant was, it was decided the complainant did not have standing to file at the first level. But at the second level, if they were the complainant in the case, they have standing to file an appeal. That can be tricky for some folks to get their heads around, even if the question is whether they had standing in the first place. And then the next court is reviewing that determination of whether they, you know, apply the law to did they have standing or did they not, based on the facts, any facts that were discovered. But if there wasn't a trial, there aren't any facts that are on the record. So it's just a matter of applying the law to, does this person have standing or not? So whereas it was determined they don't have standing below, when they become an appellant, there are the parties in an appeal are an appellant and an appellee. That's like complainant and respondent, and either one can be the appellant. So if you read GAPJC cases, it will say appellee parentheses complainant, to say they were originally the complainant, now they're essentially the respondent in the appeal, the appellee. That's legal language that we couldn't find a way to not continue to use because it's just so embedded in how we do this process. So back to examining the notice of appeal and the preliminary questions. Do we have jurisdiction? Does the appellant have standing to file the appeal? Was it properly and timely filed? And then instead of the question about stating a claim, what comes to the appellate court is the appeal states and describes one or more of the grounds for appeal listed in 60201D. So the reasons you can appeal are listed back there in 60202E as irregularity in the proceedings, refusing a party reasonable opportunity to be heard or obtain evidence, receiving improper or declining to receive proper evidence, hastening to a decision, manifestation of prejudice in the conduct of the case, injustice in the process or decision, and error in constitutional interpretation. Those are the reasons you can file an appeal. And the old rules just said you had to name one or more. We added and describe so that you're giving the court more to go on about whether something legitimately is before it or not. So it has to state and describe one or more of the grounds. If there are attorneys involved in this process, they're going to name them all because they want to have every possibility of something working and being heard by the court. And then, as with, we're to briefs already. That skipped a couple of things. If you look back at record of the case, you go through that same process again of stated clerk of the lower council listing in writing to the parties all the papers or other matters that would constitute the record. So, we just discussed the duty of the clerk of the commission in pulling all that together and essentially giving it to the stated clerk. Now it's the stated clerk's responsibility, if there's an actual appeal, to get it together and published and sent on. So same as at the first level, first you list everything that's in it. And within 15 days thereafter, the parties can challenge whether that's complete. And the stated clerk may, but is not required to amend the list at the request of the party. And sometimes those get sticky. People want things in the record that the stated clerk doesn't think belong in the record. And so that can be something that requires a hearing along the way for ultimately the old higher court PJC to determine. Then upon notice by the stated clerk of the council whose permanent judicial commission will hear the case that it's been accepted, the stated clerk from which the appeal is taken. All that is cumbersome wording, but you can't just say the stated clerk will do this, because then people say which one. So all the way through this, we say of the lower court of the higher, or lower council of the higher council, from which the appeal is taken, shall compile and file the record of the case with the stated clerk of the higher council, who shall distribute it to the members of the PJC. So all of that is just saying we build this thing called a record. In the old days, it was all literally paper that had to be copied for everybody. Now they're almost always fully electronic, and hopefully if the stated clerk or the office of the stated clerk has the technical savvy to do it, they're put together in a way that there's an index with clicks so you can jump around in the document to where you need it, so the PJC can get organized and function with it. Now we get to briefs. I need to make a mental note to go back and add a slide in there. I left some things out. So there are timelines for briefs. 30 days after the date of receiving the record, the appellant files a brief. If they fail to do that, it is considered abandonment of the appeal and the process ends. So it's a requirement. They have to do it, and they have to do it within 30 days. Then there's a part that we changed in this, and the reason we changed it is that what would often happen is that if there was an appeal and in the decision below, some things were sustained and other things were not sustained, then the appellee, the other side, wants to challenge the things that didn't go their way. So an appellant wants to appeal what they lost on, but sometimes cases aren't all one way or the other. They can be complex, and so you can sustain some things and not sustain others. So in that case, what attorneys learn and know how to do is to file a counter appeal, which means, okay, if you're going to appeal the things you lost on, we're also going to appeal the things that we lost on. And now you have essentially two cases that are before the court simultaneously that they have to deal with. To attempt to solve that problem, what we wrote language to allow is for the appellee in their brief to raise additional issues related to the decision being appealed. In other words, yes, you can name those, and instead of having to do it in a second filing called a counter appeal, where now you've got two sets of timelines to deal with that aren't the same, and it's just a mess to try to keep up with it, we're going to let you just put your issues in your brief. In which case, the appellant then has another timeline where they can submit a supplemental brief in response to those additional issues. But you have questions about that? This is new. It's never been used. because it's brand new, but hopefully it solves that dilemma of having to deal with two cases at once. In the book of orders, should D60601D, 60601D, 601D, which is the appeal states and describes one or more of the grounds for appeal in D60201. And you're absolutely right. That should be 202, not 201. Thank you, Joan. Unfortunately, that's just a typographical matter. It's one of the things that can be changed by the stated clerk office with concurrence of the ACC. So I will stick that on the list. Thank you. Okay, can the record on appeal be added to the counter appeal? Can the record to appeal? Okay, well, first of all, what we're trying to do here is avoid counter appeals. Yeah, essentially that's what would happen is in a counter appeal, the stated clerk would verify that this is the same record for the counter appeal that it was for the other one. Or to the best of my recollection, we didn't have two different records when we had to deal with those. So yes, and that, that could be, there could be a request to supplement it with additional materials that were especially relevant to the part that the counter appeal raises. So you have to take a look at that, but we ended up with one record, even though we had to process two cases, but it was cumbersome and we're trying to avoid it. So that's my best answer to that. Okay, failure of the appellant to file a brief is abandonment of the appeal. But failure of an appellee to file a brief constitutes waiver of the right to file a brief, appear, and be heard. In other words, if you're an appellee, you don't have to file a brief and participate. You can just let the record speak for itself, and there isn't necessarily any negative consequence of that. It's just that you're not there to get to argue your case. But there are times when appellees choose to just be silent and let the record speak. Particularly in things that they think are frivolous, like what I mentioned, the person didn't have standing to file. There's plenty of evidence in the record for why they didn't have standing to file. So you don't have to write a brief or appear or be heard, but you have the right to file a brief and appear and be heard. I am done with that slide, and it is 10 o'clock, so I'm going to suggest we take a 10-minute break. Thank you. All right. So moving on then with appeals, the next piece is pre-hearing conferences. Same as at the trial level, it's not mandated, but it is recommended and may be done at any time. We added a final sentence, that same as before, the top part, that the reason for a pretrial can be to seek agreement on any of the disputed issues in the appeal, and to take other actions which might reasonably and impartially narrow the dispute and expedite its resolution. We added an additional sentence in church discipline that says such conference may also result in a settlement agreement, including a request for withdrawal of the appeal, which is then processed in accordance with D605. So we went a little further and said, this can be a kind of a mediator role of the PJC to say, come on, let's settle this and not have to move forward. You can't require it, but you can at least attempt to have people come to terms on how to resolve it without moving forward with a full hearing. But then you have a hearing. And as I pointed out before, the standard of review is contained in 6-1201. That was an authoritative interpretation that was almost every appellate process in our church quoted it. And so we took it, except there are a couple of versions of it in the AIs, and my personal favorite included the line plainly and palpably wrong, which I wanted in there because I wanted the word palpably to be in the book of order, but I lost. So we went with the more standard version, which is what I already read once, but I'm going to read it again. Factual determinations by a PJC that tried the case are accorded the presumption of correctness in appeals. That is both a standard that you follow in appeals, but it's also imploring the trial court to do its best to get it right, as I already said. So the job of an appellate court is to take that set of facts, unless they're really, really totally wacky, plainly wrong, without supporting evidence, or manifestly unjust, none of which are defined terms, so you've got some wiggle room to play with. But unless they're really, really bad factual decisions, you assume their correctness. And the question is, how does our church law, how does the Constitution apply to that set of facts? And that's something about which different courts can come to different conclusions. So that's the role of a PJC in an appeal. Voting when it happens is on the question, shall the specification of error be sustained? So when an appeal happens, they allege certain errors, and those become specifications of error, or as courts usually call them, specs. So there are 10 specifications of error that come before the court. There are these 10 things that we think they did wrong. And all of those are tied to the statements in 60202, irregularity in proceedings, refusing reasonable opportunity to be heard, and et cetera. So they all have to be one of those and be named that way. But these are the things the court did wrong in the first process. So you vote on each one of them. Is it sustained or is it not? And then you give your reasoning for why. Then in terms of what you can do at the end of that, obviously, if none of the specifications of error is sustained, this is 6-1203B. If none of them is sustained and no other error is found, the decision of the lower council shall be affirmed. If one or more errors are found, the Permanent Judicial Commission may conclude that despite the errors found, the decision of the lower council is affirmed. So you can say, yes, that was wrong, but not so wrong that it changes our outcome of how the law applies to those facts. Does it count on the vote specification as part of the decision? If not, is the count available to the next higher appellate review? This one does not say, it says the vote which shall be by counted vote shall be on the question. So the answer is yes. It says in D-1202 counted vote, and that means it's recorded by Robert's rules. So yes, it is available. So back down to 6-1203C. If one or more errors are found, you can determine that it doesn't change the decision or outcome. Alternatively, it may reverse the decision of the lower council, either completely or in part. And if reversed in part, it may determine whether the decision of the lower council shall be modified or set aside, or the case can be remanded for a new trial. So those are the outcomes that a appellate court has before it. And understand, this would never be a presbytery PJC. Presbytery PJC is the first level. So it would only be a synod that could be at an appellate level in a remedial case. You could have an appeal at a disciplinary case, the final thing we'll deal with. But in a remedial case, we're talking only about synods and GAPJC that could have those. You could be a party to one as a presbytery committee of council member or something like that. But as a presbytery PJC, you would only be dealing with appeals of disciplinary cases. And then the same ending process as with a trial, which is that you can create a written outline of a decision that's prepared in session. And the written decision is reviewed by all participating members of the panel, which may take place either while the participating commission members are present or by meeting within 10 days in either in person or electronically. And as with trials, and then it is distributed and we're done. So that completes our discussion of remedial process. Anybody have any final questions about remedial before we move into disciplinary? Give you a second in case anybody's writing. All right. So we will close the book on remedial from here out. We're getting down to it here. Disciplinary process has the same 3 kinds of chapters that remedial had, plus one more. There's a disciplinary process, which is the whole preliminary part that is very different than remedial worked. Then the trial part, which is very similar to how remedial worked. And the final one is disciplinary appeals, which are very similar to how it worked in remedial. The new chapter is the chapter on censure and restoration, because if there is a finding of guilt, then there has to be a censure applied to it. And those are all defined in chapter 9. So chapters 7, 8, 9, and 10 are the disciplinary process. So let's dig in. I learned yesterday that when I get into the zone doing this teaching, I may not look down at the clock at the bottom of my screen and realize when it gets to be time for our major break. So somebody jump in and tell me if we get to noon your time and I'm still talking.
Got your back.
Thank you. So again, because a lot of things are the same, I'm going to focus on what's different. And in disciplinary process, the preliminary stuff, it's virtually all different. But once we get to those other chapters, a good bit isn't. But, for instance, there's the part about how we count days. It is verbatim. It's right at the beginning. Deadlines and filings, D70104. That's identical wording to what's in remedial. We count time the same way in disciplinary matters that we count it in remedial matters. But the way a disciplinary matter starts is very different. It's not with the filing of a complaint. And contrary to what a lot of people say, it isn't with the filing of charges. It starts with a statement alleging that a member of a congregation or a minister of the Word and Sacrament of the PCUSA, so all of us together, has committed an offense. So a statement of offense or an allegation that is written and it is submitted by a member of the PCUSA, and we'll get to that in a minute. An offense is any act or omission by a member of a congregation or minister of Word and Sacrament that is contrary to the Scriptures or the Constitution. So Scripture, Book of Confessions, Book of Order. Any act or omission that is contrary to it is an offense. How are allegations filed? Allegations are filed by a member of the PCUSA, and D702 has some wording about what happens if somebody other than a member of the PCUSA files an allegation or alleges in speech to somebody in the PCUSA that something bad has happened. The reality is it does not get before us unless a PCUSA member makes the allegation. But PCUSA members are encouraged to follow through when they have reason to believe that an offense has been committed. Even one of the, where's the clerk of session? So if you look at D70201E, members receiving allegations from any source. Members of the PCUSA who receive an allegation should file, so it's suggested, they should file a written allegation with the clerk of session or stated clerk of the council with jurisdiction. One of the things we wrestled with a good bit was very often it is the clerk or stated clerk who is the one who receives something from someone who is not PCUSA. And in order to maintain their sense of objectivity, because they have to work with both sides in any matter, their preference generally is to not be the one who makes the accusation, even if they have it because it got sent to them from somebody who's not in the PCUSA. That would put them kind of in the dual role of being the stated clerk and also being the accuser who has some defined rights within the process. So the language we added to say they may still do that is at the end of that paragraph that says, in this case, in the case of the clerk or stated clerk being the one who files the written statement of allegation, they shall not be considered to be disqualified from continuing to serve in their role as clerk of session or stated clerk. Councils may provide by rule for who shall fulfill the role of accuser in such cases. So in other words, they could file it, and then the council could determine that someone else is going to take that role on of being the one who is named the accuser for those rights later on. We don't think that's a perfect system, and most stated clerks I know don't want to be the one who files it, so they would then get someone else to file it. So I receive this credible piece of paper from someone accusing a member of my presbytery in that role. I would ask maybe the Commission on Ministry moderator or somebody else to please be the one who files it so that I can be clean as the stated clerk, and you would, and by rule, that might be the person we name to fulfill the role of accuser anyway. So that's just, you know, each presbytery, each, I suppose, session, but they wouldn't deal with it regularly enough. But presbyteries may want to consider ahead of time how they're going to handle that. And it says you can provide by rule, which means you can adopt a rule for how you're going to do that in your presbytery. Will the stated clerk make those or not? And then in our system, we've always allowed for self-accusation. And sometimes that is truly someone feels the need to accuse themselves of their own wrongdoing as part of their own process of repentance and growth. Sometimes it's a way that a person can be given an opportunity to self-accuse rather than have to be accused from the outside, and, you know, essentially submit themselves to the mercy of the court and attempt to get an alternate resolution rather than a censure. And we'll deal with all that momentarily. But that is an option in our system. We have changed in church. Oh, I'm sorry, Valerie.
Could you say a word about, well, let's start here. Synods have no members, so disciplinary is always filed at the presbytery level if it's an allegation against a teaching elder, correct? The presbytery where their membership is held.
That's correct, but one of the things we're going to talk about is reference, which is bumping it up to or requesting that the next higher council be the one that does it. And so that's the time at which if a synod were to accept a reference of the matter, then a synod could need it. That's why we are going to say here that investigating committees, all the councils need to have a rule for how investigating committees are going to be appointed, because it could happen. And so you need to have that in place. Okay. Time limits. Used to be that the statute of limitations, if you will, in our system was 5 years from the time the act was committed. That went to the General Assembly unchanged, but with a separate request from the Rules of Discipline Task Force to consider doing away with it altogether. So the committee that dealt with the Rules of Discipline Task Force had two options given to it, and they ended up with something different than either one, which is to leave 5 years, but to make it 5 years from when the alleged offense was discovered instead of when it was committed. So that makes it longer. If, for instance, someone stole money from a church and they didn't realize it until 2 years later when they did an audit and discovered that the theft had occurred, it's 5 years from when it was discovered, not 5 years from when it happened, that the statute of limitations runs out. Okay. And it also says an allegation is the starting point. I believe Rules of Discipline said no charges can occur later than 5 years from when it was committed. This says a written allegation, which adds essentially another year from when, because when you put the IC together, that's when the 1 year clock starts ticking for when you can file charges. So we've extended significantly the deadline, but there is still a statute. How do you determine that for some action being discovered? This is new. So the answer is, we'll see, Gavin. The church will have to determine. That may be something that an AI happens about. The case I gave is a pretty clean one. You do an audit report, the audit report is filed, and it says money was stolen. So that would be when it was discovered. But is every discovery of an offense going to be as clean as that? Probably not. So
I was thinking, Greg, like, for instance, I discovered 4 years ago that a pastor sexually abused a parishioner 15 years ago. How do you know I discovered it 4 years ago? I learned of it through a conversation at a Christmas party in 2020. Well, probably not 2020, but
yeah, so fortunately that one is covered elsewhere. The time limit does not apply.
Oh, that's true. That wouldn't have been a good example. I guess,
Yeah.
that's right. Maybe I discovered that they did embezzle money 15 years ago, but I discovered it 3 years ago, but I never said anything to anybody.
Yeah.
How do you know if I discovered it through? It's just my work.
Yeah. So, that'll be a factual dispute that gets settled by a court hearing the evidence and determining when they think it occurred. And it could be that the person is found not guilty because they determined that it's out of the statute of limitations or the limits. But to be clear about what I just said, after we say the 5 year time limit, it says, except in cases of sexual abuse of another person as defined in 70901, in which case the 5 year limit shall not apply. There is also no time limit to file an allegation that a person who knew or reasonably should have known of the reasonable risk of sexual abuse of another person as defined in 70901 failed to take reasonable steps to minimize the risk. That is a relatively new language in the book. The people who knew or should have known, but it was already in rules of discipline in its most recent version. And so we included it. Okay. Prior to the last revision of the rules of discipline, which was in 1995, vindication was part of the disciplinary process. From 1995 on, in the rules of discipline, there was a separate chapter on vindication requests. Vindication is someone who feels aggrieved by rumor and gossip, and they can ask for an investigation to vindicate them from the rumors and gossip running around about them. It is used, not regularly, but occasionally. But it is also has been not used well in some cases, because if I am a person who feels that there are rumors or gossip about me and I know where it's coming from, the correct thing I should do is make an allegation against the person from whom it, or persons from whom it's coming. So it was being used that way as a way to not name an accused by a person who knew good and well who they believed is spreading the rumor and gossip about them. So at any rate, we determined that it really belonged back in the disciplinary section. And so it is now D70202. It works the same way it did, which is that a member requesting vindication shall submit a written statement of the rumor or gossip to the clerk or stated clerk of the council. The council shall appoint an investigating committee in accordance with its rule. And the investigating committee conducts an inquiry and ascertains facts and makes a report. Allegations, those individuals. Yeah. So what we changed was we added a different outcome. The old vindication chapter said there are two things that can happen. One is that the vindication investigating committee reports. Period. The other outcome is that it could report that it is filing charges against the person who made the request for vindication, which is why when that came up yesterday, somebody, I forget who, said that vindication requests can come back to bite you. They can result in charges against you for when it is determined that you're really the cause or source of what you were trying to be vindicated from. But we added another logical outcome, which is that one or more people really are found against whom charges should be filed, in which case the investigating committee can do that. So that's number 3, determine that one or more other individuals who are members of the Presbyterian Church USA may have committed an offense and file one or more written, excuse me, I said charges, that was wrong. File one or more written allegations against those individuals with appropriate clerks of session or stated clerks. So it's not that they file charges and that they're the prosecuting committee, it's that they may make allegations which are filed with the appropriate person, because these may be church, this may be a minister, so it's starting at the presbytery level, but the people who against whom allegations are made may be church members of the church they serve or some other church. In which case they would file written allegations to the appropriate clerks for those individuals. That's all I'm going to say about vindication, unless anybody wants to talk more about it. Okay, moving on. Ooh, do I have reference in here? My goodness. All right, we're going to talk about reference. Next section, 704, is reference, which is very important. There is a change. Reference is asking the next higher court to take over this case. Actually, excuse me. No, we're not. We're on track. I flipped 2 pages in my book. So we're at jurisdiction. We're not to reference yet. That's why it's not there. My apologies. Jurisdiction has a standard, which is it's the council of which you're a member. That's the simple answer to who has jurisdiction. But as we know, life can get muddier than that. So there are exceptions. The language of 70301 is simply that each council is responsible for the discipline of its members and has primary jurisdiction over any allegation against one of its members, including any trial, except as provided in 201D2, 70201D2, which is if an allegation against a minister, member of a presbytery or commission, pastor in a validated ministry at the time of the alleged offense, the allegation shall be sent to the stated clerk of the presbytery with jurisdiction over the accused member of the presbytery or commissioned pastor. So first exception is ruling elders serve who are commissioned to service by presbyteries are accountable as provided in 70201. So commissioned pastors are under the jurisdiction of the presbytery if the alleged, and this is a change from rules of discipline, if the alleged offense occurred while they were commissioned. And the problem that is attempting to solve is that the old rules just said, while they're a commissioned pastor, they're responsible to the presbytery. So if they were alleged to have committed an offense and their commission was immediately ended or taken away by the presbytery, then they were back under the jurisdiction of their session. So the new wording says, if the alleged offense occurred while they were commissioned, they, even if that was 3 years ago, 5 years ago, 10 years ago, if they were commissioned at the time, it is in the hands of presbytery. So when presbytery commissions a pastor, they are assuming that responsibility for those elders during their time of commission service. Commissions, ordained ministers, the rules of discipline were a little vague about ministers who are laboring outside the bounds or who commit offenses outside of the bounds of their presbytery. It gave more of more authority to the presbytery within which the act was committed or in which ministry was being engaged. We felt that membership is paramount, that you only have, if you are a minister of word and sacrament, you are a member of a presbytery, period. You may have permission to labor outside its bounds somewhere else, but your primary membership is your home presbytery, and that is the body that is still responsible for you for discipline. There are defined instances in this section in which other presbyteries in which an act was committed or where they were laboring may be asked by the presbytery of primary jurisdiction to participate with them in an investigation. And they have certainly the right to remain informed of what's going on in the process. But your presbytery membership that examined you and received you as a member is the body to which you are accountable if you are a minister in our system. Questions about that? Okay. If a council fails to act, and this is another case, I'll get to your question in a second, going back to what Valerie said of when a higher body may take it on. D70302 says, if the council of jurisdiction fails to act in a particular case for a period of 60 days after the filing of charges in a disciplinary case, so that's later on in the process, not an investigation, but after the filing of charges, the next higher counsel, on the request of any party, may assume jurisdiction in the case. It may either issue specific instructions to the lower counsel as to its disposition or conclude the matter itself. So in that instance, charges get filed and then the presbytery doesn't move forward within 60 days to get it together. We did have one instance of that on the GAPJC when a synod had failed to act in a case. We just wrote them a very pointed letter and said, do this. Move forward, have the trial or hearing, whichever it was, and move forward. Okay, now, Jamil.
So if a ruling elder is serving on a committee of the presbytery and there is an allegation of something while they were functioning on behalf of the presbytery, is the presbytery the jury? Does that go to this?
No, it's only commissioned pastors. So if they are commissioned as a pastor to one or more validated ministries, is the current wording of the book now, during the time of that commission, they are for discipline responsible to their presbytery, but not in their work on a committee or commission. Even if it's a commission, they are church members, and for discipline, they are responsible to their sessions.
Okay.
There are cases in which people have made allegations against an entire committee or commission of a presbytery. I was a stated clerk pro tem once where that happened. Somebody alleged offenses against every member of a sexual misconduct response team of the presbytery. And what that resulted in was the need to form 6 investigating committees, one of the presbytery for the minister members on the committee, and one for each of the church members by their local sessions. And we got them all together and trained them in one training together so that they could faithfully do their work. So that's the way that happens.
Thank you.
Yep. Next, how does it work if transfer in process? So D70502 says a session shall not grant a transfer of membership to a member, nor shall a presbytery grant transfer of membership to a minister of the word and sacrament while an inquiry or charges are pending. The reasons for not granting transfer of membership may be communicated by the clerk of session or the stated clerk of the presbytery to the appropriate persons. So that's how that works. If you already took the action of transferring them, that gets stickier. But the main point is you cannot grant transfer once there's an allegation that's been received and an inquiry is in process. Okay, now we are to reference. Reference is asking the next higher body to do this on your behalf. The problem we had in rules of discipline is that it did not allow a reference to occur until an investigation was complete and charges had been filed. And what Office of General Assembly found over the years is that particularly smaller churches that were pretty much family oriented had a really hard time when there was a credible allegation against one of their members conducting an investigation of them. And there was not a way constitutionally to get a reference and have the presbytery do the investigation. What they developed as a practice was to have the presbytery assume original jurisdiction of the session so that it could do that. To avoid that having to happen, we now allow reference to be requested in multiple places. One is before an investigation occurs. So now a church that receives an written allegation against a member can ask the presbytery to do the whole thing, to do the investigation and follow through and have a trial. Or it can wait and do the investigation. Well, it can form an investigating committee, and then the investigating committee can determine that it is unable to do the investigation and request a reference. Or you can wait and do it in the old way that was in the rules of discipline, which is get the investigation done, and if charges are to be filed, then ask the presbytery to take it for the purpose of the trial. So there are now multiple times that it can happen. And that is a change from rules of discipline. Questions about that? I would note that that is only a request, and the higher council may decline the request. So D70404, in taking action on a request for reference, a permanent judicial commission may take either of the following actions. If the permanent judicial commission decides to accept the reference, it shall instruct the stated clerk to proceed with the appointment of an investigating committee if needed, meaning that's when they ask for it. The permanent judicial commission shall conduct the trial or hearing on appeal. The higher council's permanent judicial commission may decline to accept the case for reference and return it to the lower council, stating its reasons. The session or permanent judicial commission of the lower council shall conduct the investigation, trial, or hearing on appeal and proceed to a decision. While a request for reference is pending, and until the higher council acts to accept or decline the reference, any pending deadlines or periods of time for action by a council party or IC shall be suspended. So that's the whole process. They have to have time to make the decision. And in the case of a presbytery where this is most likely to occur on a request from a session, presbytery PJCs often haven't even met, or have met barely to get organized, and now they have to pull a meeting together. So it can take some time to make that happen for them to make a good decision on whether or not to accept it. And therefore, we don't want timelines for filings to get in the way of that. And so the time clock stops during the time the request from when the reference is requested until the decision is made. Okay, questions? We've got about 10 minutes, so I'm going to get started on investigating committees. The new rule says D70501A. This is new. Sessions may and councils above the session shall provide by rule for the appointment of an investigating committee. That's another little piece of work. If your presbytery does not already have a rule, rules of discipline just said councils may provide by rule. And some did, particularly ones that are like larger presbyteries often have dealt with a number of these and done it enough over the years that they have. The presbytery where I serve rarely has such cases. And in a case where we did not yet have a rule. We do now, but we did not at that time. And what that meant was we had to call a presbytery meeting for the purpose of the stated clerk saying, I've received an allegation and we need to appoint an investigating committee. And I recommend that these people be appointed to appoint that committee. Why do you do it that way? Because what if somebody nominates somebody who is the accused, right? And your rules also need to be written well so that they account for that fact. What if the allegation is against the presbytery executive, and the presbytery executive is one of the people who's supposed to be naming the investigating committee? They can't do that. So you have to have enough people in the rule that you can work around. If one of them is the accused, then they're obviously not going to be one of the ones who appoints the investigating committee. So make a rule, look at your rule for your presbyteries and synod, and figure that out.
Or they could just refer it up to synod, right?
They could ask for a reference to synod.
That's what I mean.
Yes.
Right.
So if it's, yes, I mean, you can ask, but if our synod got a request from a presbytery, they'd have to have pretty good reason for why we would do that, I think. You know, the scenario that is more common is a small church has trouble disciplining its members and it would like the presbytery to do it for it. Whether that's true of a presbytery or not with its members, I don't know if that would happen. But the book says you shall have a rule. So I would say you need to have a rule at every one of our council levels above the session. And if you're a large church, I would recommend that you have a rule as well. So the beginning of that section says, when a clerk or stated clerk receives an allegation without undertaking further inquiry, the clerk shall then report to the council that only that an offense has been alleged without naming the accused or the nature of the offense, and refer the statement of allegation promptly to an investigating committee, which shall conduct the inquiry, and the process for that is below. And once that has happened, transfer of membership is prohibited until the matter is concluded. Clear on that? So before we get to, yeah, I think we can figure this out. The next couple of pieces, 30102 states the moderator, person review. Oh, you know what? I think I'm going to say let's stop here. We're